Hello everyone, how are you all? Hope you are all fine. This is Komal, mathur, a legal intern at LEXIS and Company and a law student at Manipal University, Jaipur. Today we are going to discuss about live-in relationships versus morality, a case for strengthening Domestic Violence Act. Supreme Court of India, for the first time in case of S. Khushbu versus Kanyamal 2010, gave legal recognition to live-in relationships by categorizing them as domestic relationships protected under Protection of Women from Domestic Violence Act 2005, also known as DV Act. The court held that a live-in relationships come within the ambit of right to life enshrined in Article 21 of the Constitution of India. The court further held that live-in relationships are permissible and that the act of two adults living together in any case cannot be considered illegal or unlawful. However, they have become a developing area of controversy with respect to the types of live-in relationships that are recognized. The Supreme Court in Indra Sharma versus V.K.V. Sharma 2013 categorized live-in relationships into two: domestic cohabitation between two unmarried individuals and domestic cohabitation between a married and unmarried individual or two married individuals. Supreme Court has only recognized the former and not the later. This article explores the contours of the validity of the later category of relationships. Now, what are the conflicting views of the courts? The High Court of Bombay, Allahabad and Rajasthan have repeatedly refused to grant protection to such live-in relationships, citing reasons that a live-in relationship between married and unmarried person is illegal. The Punjab and Haryana High Court went a step further and referred to these relationships as unacceptable, claiming that they destroy country's social fabric. However, the Delhi High Court, taking a contrarian stand, adopted a wider approach, upholding the rights of a female live-in partner, irrespective of the marital status of the both individuals. Nature of relationships and bigamy. Section 2 Clause F of the DV Act defines a domestic relationship as a relationship in the nature of marriage between two people or adults living in a shared household. There are two main reasons for recognizing relationships in the aforementioned later category. Firstly, in our opinion, live-in relationships involving a married person fall within the four corners of domestic relationships under the DV corner. Now, this view found judicial endorsements by the Madras High Court in the case of Muller Cody Muller v. versus the Chief Internal Audit Officer 2021, wherein adopting a wide interpretation of Section 2 Clause F, the court acknowledged it to be broad enough in its scope to encompass relationships of the aforementioned later category. Furthermore, it is pertinent to note that the definition of live-in relationships as the law is understood currently has conceptualized during the erstwhile adultery regime, which has since been declared unconstitutional by the Supreme Court in Joseph Shine versus Union of India 2018, thus wiping off adultery from the criminal statute books. In view of this, it is imperative that the aforementioned later category of live-in relationships must be recognized, particularly from the perspective of the DV Act. Secondly, a strong case can be made that the live-in relationship between a married person and unmarried person does not fall within the penal scope of bigamy, which is Section 494 of Indian Penal Code. The provision is explicitly clear that it is only a second marriage during the lifetime of a husband or wife that can attract criminality. Nowhere does the section say that the live-in relationship which is in the nature of marriage will be considered to be an implicit marriage under personal law. The object of the DV Act was primarily to provide protection for the wife and female live-in partner from violence at the hands of the husband or the male live-in partner. When a woman, whether married or not, is in a domestic relationship with a man, the focus of DV Act violation inquiry is centered on the tangible harm caused to the women and the consequent protection of the women. Any denial of protection would be a grave injustice to the women who are suffering. Unfortunately, the Bombay, Allahabad, Rajasthan, Punjab High Courts have denied such victims protection on the moral grounds that such relationships violate the sanctity of marriage and promote bigamy. However, we respectfully disagree. The courts could not be further away from the correct position. Acceptance of the aforementioned category of the live-in relationships as akin to a domestic relationship for the purpose of Section 2F of the DV Act does not ipso facto promote bigamy. No, it an attack on the institution of marriage. By just considering the living couple to be in a domestic relationship, the married woman wife is not being deprived of her matrimonial rights of maintenance, legitimacy, and custody of children, etc. It merely acknowledges the existing factual reality of our society and assuredly promotes the salient goals of protection of women enshrined in the DV Act. So that's it for today. Thank you everyone. Have a nice day.